today's proceedings for the meeting of the Electricity Subcommittee, which is a special meeting held today, the 27th of May 2025. This is meeting number 243. In today's meeting, I have the members of the energy regulator that are going to take decisions. I would like to introduce them so that you can recognize their voices when they speak. I would like to start with myself. My name is Nomfundo Maseti. I am the member of the Electricity Subcommittee, chairing this committee, as well as the member of the Piped Gas Subcommittee. With me today, I have the chairperson of the energy regulator, Mr. Thembani Pukula. I would like Mr. Pukula to introduce yourself, please.
Thank you, Chairperson. Good afternoon, everyone, and thank you, Chairperson.
Thank you very much, Mr. Pukula. The next member that I would like to introduce is Advocate Nomalanga Stole, who's the CEO of NERSA and also the member of the Electricity Subcommittee. Advocate Stole.
Good afternoon, Chairperson, members, and everyone who has joined us for this meeting, for the special meeting this afternoon. Thank you.
Thank you, Advocate Sitole. I would like to also introduce Ms. Tembe Kasemane, who is the chairperson of the Finance Committee at NERSA, as well as the member of the Electricity Subcommittee. Madam Semane.
Afternoon, Madam Maseti, and good afternoon to the members of the public as well as our NERSA colleagues.
Thank you very much, Madam Samane. I'd like to now introduce Mr. Muzi Mkhize, who is the full-time regulator member, primarily responsible for petroleum pipelines, and is also the member of the Electricity Subcommittee. Mr. Mkhize.
Greetings to you, Chairperson, all in attendance, as well as the members of the public that are following us through the various live streaming platforms. Thank you.
Thank you very much. These are all the members that are going to contribute in today's deliberations and take decisions. Members, we are now on the adoption of the agenda. The agenda is proposed, members, and I would like to check if members are in support of the agenda by raising your hands, members. Thank you, Madam Samane. Thank you, Mr. Pukula. Thank you, Advocate Stole. Thank you, Mr. Mkhize. I also support. Thank you very much, members, for approving the agenda. Members, on the declaration of interest, the forms have been uploaded. If you can kindly remember to complete the forms, submit them to the secretary of the committee for record purposes. But I would like to also just check if members have anything that they would like to declare on the agenda verbally. Any verbal declarations by show of hands, members? There is none. Thank you, members. We then proceed to the consideration of the members for the matters that require our decision today. On item number 5, we have the publication of the consultation paper on ArcelorMittal South Africa, a 6-year negotiated pricing agreement application for the Newcastle as well as the Vanderbilt Park plants. It is here for approval, the consultation paper for approval and the noting. Please introduce the matter.
Am I audible? Audible, Chair?
Yes, you are audible, Mr. Shozi. If you can just raise your voice a little bit.
Okay, thank you, Chair. Good afternoon to you, members of the Energy Regulator and colleagues and members of the public. Chair, I will just take you through on the high level of this, the purpose of this submission, and my colleagues will come in with the details. Chair, we are here to the subcommittee to request the approval of the publication of the consultation paper which seeks to solicit comments from the members of the public as well as the industry around the rejection of the application by ArcelorMittal, Newcastle ArcelorMittal Funded Bay on the negotiated price agreement. Chair, the two plants submitted an application to Eskom in terms of the framework, the NPA framework, and then Eskom reached a decision not to support. Therefore, they submitted a letter to the energy regulator rejecting the application by AMSA. Chair, on those bases, we started with getting more information from both Eskom and AMSA. We have had a number of meetings, 2 meetings with AMSA and Eskom. What we ascertained at the time was that Eskom had not formally submitted an application to recommend the rejection of the NPA to NERSA as per requirement of the NPA. Subsequent to our engagement with Eskom then submitted the application to recommend to the energy regulator to reject. But what I need to highlight, Chair, is that normally there will be a price or the decision that Eskom will recommend to the energy regulator to either reject or support. In this case, there is no tariff that has been recommended. Eskom has just completely rejected the application on a basis that will be highlighted by colleagues. Chair, with that, let me invite Mabinya to give full details on how we have arrived at today, and then what the silent point of the consultation paper, and then we'll invite members to engage on our submission. Over to you, Ms. Mabinya. Thanks, Chair.
Thank you, Mr. Shozi. Good afternoon, members, colleagues, and members of the public. Over and above to what Mr. Shozi has said is that Eskom assessed these two applications against the criteria outlined in the framework. And in addition to that, they also assessed the application against the parameters that are not in the framework. And then they decided that these two plants do not meet the criteria. And I'd like to bring to members' attention that the Department of Trade and Industry and Competition supported these two applications in terms of section 4.10 of the framework. And because Eskom rejected these applications, AMSA then appealed to NERSA directly to reconsider these applications for these two plants. And then AMSA made this request in line with section 12.12 of the framework, which allows the applicant to petition NERSA directly. And AMSA's ground for asking NERSA to reconsider the applications are outlined in paragraph 5.9 on page 4 of the submission. And as Mr. Shozi has indicated, that following our engagements with AMSA and Eskom separately in April, this resulted in Eskom making a formal submission to NERSA in May. This was in accordance with clause number 12.12 of the framework, requesting NERSA to consider its recommendations for the rejection. And the reasons given by Eskom for the rejection are also outlined in paragraph 5.7 on page 3 of the submission. Chairperson, I think it is important to note that the energy regulator in this case is in a very unusual situation in that we are not consulting on the actual NPA, because Eskom rejected these applications before any price agreement was negotiated. We are simply consulting on the AMSA applications for the purposes of assessing whether Eskom's rejection is correct or not. And we are doing this because AMSA approached NERSA directly, and also because the framework enables NERSA to make the decision, the final decision on the application of any NPA. We therefore, Chairperson, request the ELS to note the request by AMSA for a six-year NPA application for its Newcastle and Van der Bay Park works, and approve the publication of the consultation paper on AMSA's 6-year NPA application for the Newcastle and Thunder Bay Park plans, and also note the proposed timelines outlining the consultation process. Thank you, Chairperson.
Thank you, Mr. Mabinya. I think it would have been helpful that you touch on the specific criteria so that the members are aware as to your own independent assessment in terms of whether AMSA meets the criteria in terms of the consumption, the load factor, and all of those. I think that is important. And also, just to clarify, even though there is no specific tariff, because obviously the licensee is the one that would have to agree with the customer, which is AMSA, as to what will be the acceptable tariff at this point. Sorry, the tariff in terms of the NPA. What is also important is to clarify to the members what happens after the customer has approached the licensee, in this case Eskom. What then happens? Whether Eskom agrees or does not agree, what does the framework say in terms of the recommendations? Because the framework does not contemplate only recommendations that are in support of the application. The recommendation can either be to accept the application by the customer or not to accept the application to the customer. But at the end of the day, the framework requires that there be recommendations. So in this case, the recommendations by the licensee is the rejection. So I think it's important that just to touch on what direction do we get from the framework, but start off with the criteria, please.
Thank you, Chairperson. Chairperson, in terms of the criteria, there are certain aspects that the application meets in terms of the annual consumption of 80% that is required by the framework. Both of the plant meet these criteria. And in terms of the load factor, both plants do not meet the 70% load factor required by the framework. However, the framework simply says an applicant can either meet the annual consumption of 80 gigawatt and or a load factor of 70%, and it is NERSA's understanding that the interpretation of the framework simply means that one of each can be met by the applicant, and in this case, AMSA has complied in terms of the framework. And our understanding is that the AMSA 2 plans could qualify in terms of the framework. And then in terms of the recommendations, in terms of the framework, NERSA is required to process the application as submitted by AMSA. And then it will therefore need to inform the licensee of its decision. However, if NERSA does not get involved in the formal agreement incorporating all commercial and legal aspects of the NPAs, that must be entered into between the applicant and the licensee. Thank you, Chairperson. I think I've covered the questions. Thanks.
Thank you very much. Members, any questions, guidance, input from your side? A show of hands, members. Thanks, Mr. Pukula. You may go ahead.
Thank you, Chairperson. Chairperson, I know that we are talking about we're not in the consultation paper as yet, but I just wanted us to clarify in our own submission the way that we are packaging this. For instance, on paragraph 4.2, we clearly state that these were assessed by ESCOM, but they didn't meet the criteria according to the criteria. But when we go to 5.6, we then say that it was ESCOM used other parameters that were not in the framework. So we are miscommunicating a little bit there. We can say that AMSA alleges that that was the case, and yeah. So that's the first thing. The second part for me, like on 5.11, I think our being conclusive there. In that would appear that AMSA could qualify. I'm not opposing that could be, but I don't think that the things that we have said in 5.10 and all of the sentences above that justify that sentence that we are making there. And I will park here, Chairperson, before then I go to the actual questions that we are asking in the consultation paper. Thank you, Chair.
Thank you very much, Mr. Pukula. Advocate Stole.
Thank you, Chairperson, and thanks to the presenter. Chairperson, I'll start with the point that Mr. Pukula mentioned, because I had it as well on 5.11, to say that maybe that first part that start with, it will appear that AMSA could qualify. Maybe if we delete it, and such that that 5.11 links up with 10, because we are trying to explain what is the need for us to have this public participation that we are wanting to have in terms of issuing this consultation paper. So if that can just be maybe considered in terms of having to delete that first part. The second question, Chairperson, is for me, it's a question of clarity on the criteria required. Maybe I missed Ms. Mapinga in her verbal presentation to say, she mentioned that the annual consumption required, it's 80%, load factor 70%, but I didn't get it as to whether the framework does require that an applicant should have both, meaning both the annual consumption of 80 and as well as the load factor. She seems to be saying rather, the applicant should have one of the two. If she can clarify that for me, and as well as the other parameters that are not in the framework, maybe if she could just give us an elaboration on that. As to what are those other parameters. I may not have picked them up in the submission, and I'll appreciate it if she can just share that with the meeting. Thanks, Chairperson.
Thank you very much. Mr. Mkhize.
Thanks, Chairperson. Since we've got, and thanks to the presenter, since we've got a framework here, I think if we trace it back to the law and then we go to the framework in terms of the criteria, I would agree with my colleagues on the matter of being consistent and seeing that this is a document for public comment. I think it would also be better to have a measured level of neutrality so that we can really be soliciting comments on a neutral basis, so to say, looking at what is here. But what is a bit concerning to me, if they can also maybe clarify the process. Maybe I've not seen it as I was in terms of what is being presented before us. Qualifying us to this kind of an intervention, because you expect that when there is an agreement, there should be an agreement between the parties, and then these parties now, they solicit our approval and not come in and broker. If that also can be beefed up, so it comes out very clear, our intervention and what actually it means when there is no agreement, because this is an agreement between parties for our approval with a certain price attached thereto. So just that legality, if it can also be cleared. And then also why in this instance, because it will also help to reflect on the framework itself, such that it is very clear cut in this regard in terms of the criteria. If also we may look at certain way in which the criteria could be formulated such that there is no ambiguity and we kind of avoid this kind of a situation. Thank you.
Thank you, Mr. Mkhize. May we then receive the responses from the team? If you can also just be straight to the point so that members can get sufficient explanation and clarification on the questions asked. May I invite first, because I see there's no one who's raising the hand now, may I invite Mr. Morati to come in on the issue of the legal clarification when there is no agreement, taking into account the point made by Ms. Babinya earlier on that NERSA does not entertain contractual or pricing negotiations. Do we have Mr. Morati? Thank you.
Good afternoon, Madam Chair and regulator members and fellow colleagues. Chair, maybe just quickly to just take it maybe a step back where this whole issue commences that the powers of the regulator, it's such to approve the prices and the tariffs. And in this regard, the provisions of Section 15 enables a situation where from the approved tariff, an applicant or a customer may approach the licensee for a deviation from that tariff. And the electricity pricing policy details the principles that must be observed, which resulted in the interim framework that is supposed to be issued by the department, which has been used in this circumstance to process this. But specifically that as Ms. Mavi has highlighted, the applicant cannot approach the regulator directly for a change in the tariff. Has to approach a licensee, which in this instance, AMSA approached ESCOM. And ESCOM has that obligation as initiated in the framework to assess the application. And in it up making the application, it has to communicate back to the applicant what it is recommending. It is not the decision. The framework makes the regulator the final arbiter of that process. And in this instance, when the recommendation that ESCOM has made comes to the regulator, the framework goes further to provide that if they were in the instance where the recommendation is the rejection, the licensee must also submit the application that it has received from an applicant to enable the regulator to assess such an application within the processes that the regulator would have determined and make a decision on that. And the decision on that relates to whether the recommendation that has been made by the licensee, it is approved, or the recommendation it is rejected. So that is the principles that between the primary legislation and the pricing and the electricity pricing policy and the framework, they link up to not deprive the regulator that powers to approve the tariff and not get into the dynamics of engagement within the negotiations of that NPA. because other circumstances where there's such a rejection, the applicant may adopt a different approach, but the issue of pricing resides with the regulator. I will pause, Madam Chair.
Thank you, Mr. Murati. Mr. Shozi, may you please provide responses to the other questions? I think on paragraph 5.6, is it 5.6 or 5.10? That one, take it as a given. I think it's just the way that it is phrased. So at that stage, we are not analyzing. You have not been analyzing, but you are simply stating what is indicated by the parties. So if you can kindly state that if it is AMSA that mentioned that ESCOM considered or assessed the application using other parameters that are not provided for in the framework, if that is the statement made by AMSA, let it be reflected accurately as such in that paragraph. But you can respond to the others and clarify if this is a statement that we came up with or is a statement that is made by AMSA. Thank you.
Thank you, Chair. The comments from Mr. Vugula, I note them some as enhancements to the submission. The letter from AMSA or ArcelorMittal, they state 4 bases at which ESCOM rejected the application, and they further say they are saying ESCOM had not considered other factors that could have enabled them to be eligible for the NPA, which are mentioned in section 7 of the clause. So without getting into details, I think they are just saying that there are some other factors that were not considered by ESCOM, but they were very specific on their letter which one that were considered, and they of the view that the applicability of the framework by ESCOM was too mechanical. They could have considered other factors that are within the framework. And I think the issue of the 5.11 again, we take that as an enhancement to improve the submission. I can't remember which other question, Chair, that were not answered by Ms. Babini that probably I need to that I need to add on, if I may be checking on those ones. My apologies for that.
Thank you very much. They may also come in to respond to the other questions. There are questions from Advocate Sitole, and I think the questions from Mr. Mkhize were clarified by Mr. Murati. So can we also just get the responses, Mr. Mabinya? Sorry, Ms. Mabinya, on the other questions and the other team members.
Thank you, Chairperson. I think in terms of the criteria, section 7.4 of the framework clearly indicates that an applicant must have a minimum of 80 gigawatt and or load factor of 70%. So our understanding, to respond to the CEO's question, is that an applicant can have one either the consumption or the load factor. And then also in terms of the 7.2, which states that electricity must be a significant driver of the operating cost. The framework does not dictate on what that percentage must be, but ESCOM's reason was that an AMSA does not meet a certain percentage in terms of the criteria.
Mention the percentage. Please mention the percentage.
It's 30%. It's 30% that ESCOM wants, and they are saying that AMSA has not qualified in terms of that. And another criteria that is not in the framework is the fact that an applicant needs to produce a certain level of tons in terms of e-production when for an applicant to qualify for an NPA, and ESCOM has indicated that an applicant needs to produce intensity of 1 megawatt per ton, and that the two AMSA plants have not achieved that. And that requirement also is not outlined in the framework. It's not in the framework. I think the other team members can add if I've left out something. Thank you, Chairperson.
Thank you very much. Let me check if the members are clarified, starting off with Mr. Pukula. Mr. Pukula, are you clarified on the questions that you have asked?
Yes, Chair, I'm clarified. Like I indicated, the others are really on the actual consultation. In fact, for me, it was really enhancements more than being clarified. Thank you, Chair.
Okay, thank you very much. Yes. Advocate Sithole?
Chairperson, I'm covered. Thank you to you and the team. Thanks.
Thank you. Mr. Mkhize?
Thanks for the responses. I'm kind of not, it's not crystal clear to me. There's a difference between appealing a decision by a licensee to an authority and the licensee seeking the authority's endorsement on its decision on a particular request by an entity that is not a licensee. The way it is explained, it seems as if the decision must be taken and endorsed by the authority and not necessarily appeal to the authority. So if they can just look at the legal side of things to see what this actually entails. Because it touches on the issue of forcing a decision, forcing an agreement also, where there is no agreement to start off with. I think it's important just to clear up that first part. As I said, I still maintain that in terms of how we're approaching it, move really from the legal side, what empowering provisions, what the framework says, so you can also be able to provide the feedback to the policymaker in terms of improvements on the framework, even improvement in the sense of how to deal with it in the interim. I'll leave it at that. Thank you.
Thank you very much, Mr. Mkhize. Mr. Murati, I think you did clarify the other legal part and all of that. Maybe because I think you did two things. You provided the context from Section 15 and also the grounds for the framework, which is from the EPP, from the Electricity Pricing Policy. You went on as well to talk about what is stated in the framework, which is the recommendations. So the recommendations can either be agreement or the recommendations can be a rejection. Can you now talk about what is before us? Because what is before us at this point is not an appeal. We are not looking at an appeal here. We are talking about what is the outcome after the two parties have spoken, meaning once there is an application, the framework talks about an application, and the only thing that it says about the application, it means is an application from a customer. So the customer brings an application to the licensee. So that is the first step. The licensee considers looking at the criteria set out in the framework. That's step number 2. The licensee comes to a decision. In that decision, the licensee then must make recommendations once the licensee has made its assessment. So it comes to the recommendation. What is before us now on the outcome of that process is a recommendation, not an appeal. But then once the recommendation is a rejection, then it requires, therefore, so that NERSA then, once it looks at a recommendation, NERSA must look at the information that was presented to the licensee to see whether the licensee has applied the framework fairly, not in a discriminatory manner, and whether it did not unduly disadvantages the customer. So before us is a recommendation. Mr. Moratti, can you assist us on that? I just wanted to touch on those steps so that they are very clear. We're not looking at an appeal before us. We are looking at a recommendation because that's what we're waiting for. Can you please deal with that, Mr. Moratti?
Chairperson, if I may just chip in, sorry, before Mr. Moratti, just to say that, sorry to do this, but to say that then it means that whatever is done, I think it goes back to what Mr. Pugula also highlighted and advocates told, to say, let us make sure that we then use the right wording. If you look at 4.3, it talks to an appeal. So I'm saying, let's just ensure that whatever the explanation that we get here, we also work on the wording. Thank you.
Thank you, Mr. Mkhize. Mr. Moratti, can you please also just for the record indicate clearly whether what has been articulated from the process point of view and what is provided by the framework, whether what is before the members today is that recommendation, because that's where we need to start on the recommendation. Thank you.
Thank you, Madam Chair. You are very correct that what comes before the regulator, it is not an appeal, because the framework details the regulator as a final arbiter, and provisions of section 1210 is the one that deals with the recognition of the recommendation that is supposed to be made by the licensee. And in the instance where there is a recommendation for rejection, which is what we have, the framework in section 1212 provides and compels the licensee, when making a rejection recommendation, that they must submit the application, as the chair has outlined, that has been submitted to the licensee in the first instance, to the regulator for an assessment. And again, the framework provides and enables the applicant to petition the regulator, which the content of such a petition forms part of the assessments that, and my colleagues have explained that part, that raising the issues that AMSA has touched on. So what is before the regulator? It is the recommendation and the consideration of that recommendation. But that consideration should be based on the application and the petition to arrive at the decision to either approve the rejection recommendation or to reject the rejection recommendation. I will pause, Madam Chair.
All right, thank you very much, Mr. Moratti. May I then, I think the team has taken note of the appropriateness of the language or the words that are used. For instance, where we talk about, the team talks about application as opposed to the recommendations and the other terminology that is used. It must be used appropriately so that it is not confusing. So that's the first thing. Secondly, also, things that are stated by the parties must be stated as assertions made by the parties rather than as factual statements that the energy regulator makes. So that is the second thing that the team must correct. May I now invite the members of the electricity subcommittee just to guide on the consultation paper, maybe just the substantive issues that the team needs to correct so before the document goes out, at least things that will avoid confusion and will also avoid statements of facts or statements that suggest that the energy regulator is kind of making a decision to the effect that there is an agreement that should be reached by the parties. If I can just invite the members of the regulator to assist there. By show of hands, members. Mr. Pugula, thank you very much. You may go ahead.
Thank you, Chairperson. Chairperson, I don't know if it is a question of style or preference, but I suspect that in some of the questions, it is not a question of style or preference. I mean, we shouldn't be asking them like that. If I start with the stakeholder, question number 1 for stakeholders, where it says that do they align, I think I would let that go. But question number 2, where we're saying, are these plants electricity intensive for the purpose of eligibility? I am not sure if the members of the public would answer that. It is determined in the framework what is eligible and what is electricity. So I'm not sure if we should ask it like that. I don't know what we're expecting, because I mean, there's a saying that sometimes when you ask questions, you must have an idea of what the answer would be, and if it's something that we have an idea of what that answer would be. But when you go down on them, there are questions. I'm not sure if we are querying the framework, because the framework is there. If electricity is not within the top 3 of the highest, I'm looking at stakeholder question number 5, for instance. Should ESCOM look on the other elements, because the actual effect that such closure could have, I don't know what we want to achieve with that. And then even number 6, I don't know what is the purpose, what we want to achieve. But when we get to 7, when we say a pronouncement by government compelling for consideration by ESCOM, what are we expecting then, and why are we asking that question? I don't understand. I further don't understand when we expect stakeholders to answer a question. Is it reasonable to reject an NPA application? We can, I mean, if I were to phrase that, what are your comments on ESCOM's rejection of the application based on the load factor and that, not whether it's reasonable or not? Is it imperative? No, I think the structure generally of these questions is not how, as a regulator, we should ask them. I don't know if it's a question of the style of writing, but for me, I don't think that we should be asking if it is reasonable or not. But we should just ask for the comments of the stakeholders on the rejection, which is what we're dealing with. Thank you, Chairperson.
Thank you very much, Mr. Pugula, for that guidance. I think it is very clear in terms of how these questions should be framed. Let me check if other members have questions. So, any guidance on the questions asked? All right, Mr. Shozi, this is really guidance. So once a question is asked, we must also anticipate what is the usefulness of the answer that we are looking for. So it starts with the understanding of the process that we have embarked on. As you have had one of the questions that could be posed. For instance, you want to ascertain whether the rejection was reasonable, given the factors, what is it, the criteria in the framework, and you also want to ascertain whether the assessment that has been made, but you must be specific whether the assessment has been made, it was made accurately by the licensee under the circumstances, as opposed to putting certain things. So I think, members, if you are comfortable, the team will rephrase the questions so that the consultation paper can go ahead. I will also just have to try and sit down with the team just to assist here and there in terms of the questions, just to rephrase the questions and make sure that we still get the gist of what the team is trying to ascertain from the stakeholders. If members are happy with that, as well as to correct the language that has been used. If members are happy that the questions can be rephrased, I would like to then maybe take the members to the decision that is sought. Firstly, that they note the recommendation from ESCOM, which is the recommendation that NERSA rejects I'm adding members. That's why I'm kind of sort of because we need to reflect that. So to request the electricity subcommittee to note the recommendation made by ESCOM that the energy regulator rejects the NPA application brought by AMSA. So that is the first thing. The second thing is to note the submissions made by AMSA regarding its application to ESCOM and the reasons why it believes it qualifies in terms of the framework. That's the second one. The third one is for the subcommittee to approve the publication of the consultation paper on AMSA's 6-year NPA application and the recommendations made by ESCOM. On this one, it is subject to the corrections that and enhancements that were pointed out by the members. Then lastly, the fourth thing is to note the proposed timelines outlining the consultation paper. Members, if you're happy with the four recommendations from the team, with the one that I've added, members, may you please then raise your hand to show support of the four. Thank you, Madam Semane. Thank you, Mr. Pugula. I also support. Thank you, Advocate Sitole. Thank you, Mr. Mkiza. Thank you very much, members. Your input and guidance is well appreciated, and the team will make sure that it acts with speed in terms of rephrasing the questions and also the terminology in the document. Thank you very much, members. Members, this is the only item that we are required to discuss in the open meeting, and therefore I would like to close the meeting at this point for the members of the public and just to thank them for following and showing interest in the NERSA business by observing the discussions and